Good afternoon, everybody. Thank you for joining us today. As we wait for everybody to settle in, now is a great time to make sure you have any snacks, coffee, water, whatever it is to get you through all the information that's going to be coming your way soon. To make sure we're all in the right place, this is the Mid-Year Labor Law Update sponsored by the City of Glendale. My name is Stephanie Neely, and I'm the Marketing Director here at CEA. Before we start the presentation, we have a few housekeeping details to go over with you. Your audio will be muted throughout the presentation, but we ask for your comments and participation in the chat box. That's the single speech bubble at the bottom of your screen. That's where you can put any comments you have, any technical questions, anything like that. Pop it in the chat box. If you have any questions about the content, you can type them into the question box, which is the icon with two speech bubbles at any time, and we'll try to address them as we go. The slide handouts for this presentation were attached to the reminder emails. I will also pop them into the chat box in just a minute, so you can download them from there if you need. And if you need any additional help, please let me know in the chat box and I'll help you out. This presentation will be recorded and will be made available to everybody through the City of Glendale's website, so keep an eye out for that URL. And at the very end of this presentation, there will be a survey. Because your feedback is very important to us, please complete the survey. A QR code will pop up, snap a picture of it with your phone. It won't take you more than a minute or two to complete. I promise we'd love to get your feedback. What did you like? What do you think you would like to see next time? Topics you'd like to see? We want to hear it all. All right, before I pass this over to our presenter, I would like to introduce Sev Deshoyan from the City of Glendale to say a few words.
Thank you, Stephanie. Hi, everyone. I would like to, first of all, thank you all on behalf of City of Glendale's Economic Development Division for joining us today. Our division's focus really is on assisting the business sector in the city, and we do so through our plethora of retention and expansion business services. But given the topic of the day is the mid-year labor law update, I wanted to shed some light on one of our core services that we offer in partnership with California Employers Association, actually, which is our free HR hotline. So at any moment in between Monday through Friday, 8 a.m. to 5 p.m., experts can provide you guidance and assistance on any of your HR questions that you have or any HR-related issues that you're experiencing at your business, and can also provide you guidance on main topics such as hiring, firing procedures, rules and regulations on paid sick leave, breaks, and remote working, and much more. If you'd like to learn more about our economic development related services, I would highly encourage all of you to visit chooseglendaleca.com or contact me. I will leave my information in chat, and I will be more than happy to assist you with your business related issues, or at least guide you to the correct place to get the situation fixed and started. So with that being said, I would like to kick it back to Stephanie to introduce our speaker.
Thank you so much, Sev. We hope to hear from you all on the hotline soon. All right, your speaker today is HR Director Eli Nunez. So without further ado, take it away, Eli.
Thank you, Stephanie. Thank you, Seb. And thank you very much to the City of Glendale, too, for this partnership and for allowing us to speak. Look forward to presenting this for you and hearing from you on the hotline with any questions, either about this presentation or anything else you need. Sometimes, there's a situation that comes up that's HR related that you just need to talk it through, need to have a fresh set of ears on it or something. Give us a call. That's what we're here for, Monday through Friday, 8 to 5. A little bit more about us. We are California Employers Association, and our goal is to provide our members and our callers, the City of Glendale, that would be you, with peace of mind. So we do that by providing trainings and webinars, such as the one you're joining us for today. We also, pride ourselves on giving quick and responsive answers to HR questions. So when you call on the phone, you're either going to be passed right on to a live person on the phone, or you will receive a call almost immediately afterwards once you leave that message there. So top of that, we also have other resources such as forms, policy templates, handbooks, that sort of thing that are available either for sale or through membership, as well as different trainings, be it for supervisors, employees, whatever it is. Basically, any HR related topic you could think of, chances are we probably have a resource out there that can help you out with that. So keep us in mind and keep that hotline handy with any HR questions. Having said that, we are a lot of things, but one thing we are not, and one thing I definitely am not, is a lawyer. So we do not give legal advice. This presentation should be taken as for educational purposes. And even though we'll talk about some, court cases, laws, that sort of thing, this is not legal advice that we're dispensing today. So we always recommend, if you have any questions of legal nature, of importance to your business, please consult legal counsel, your attorney, whatever it may be, so you can have the attorney-client privilege and they can guide you through that situation. So having said that, now we get the fine print out of the way, let's talk about some of the topics we'll be touching on today in this mid-year labor law update. First of all, we'll touch on some of those wage and hour updates, which, as you know, these things seem to change sometimes more often than yearly in the state of California. Workplace violence prevention, or the WVPP, that's a new requirement in the state of California this year. Came about mid-year. We'll talk about a little bit about what it is and what you need to do to comply. New rights for pregnant workers. Aside from all the protections California already offers, there have been some changes this year. So we'll talk about that along with some other topics that we usually get questions from, or that we've gotten questions from our callers and on the hotline throughout the year. So with that, let's go ahead and jump right into those wage and hour updates, because we know, I mean, those are the biggies, right? When you're running a business, it's that money output. That's the one that has the biggest effect on you. So let's talk about some local minimum wages, compensable time, some few other things that have changed this year or that have been updated. And the first one, of course, is, we know you're all aware of it, was the change in minimum wage for the state of California. This changes of January 1st of this year, possibly more changes coming. It seems like we're getting an increase every year now. And the reason for this is there was a law that was signed back in the Jerry Brown days, before Gavin Newsom, that stated that whenever inflation was beyond a certain point, it would automatically trigger an increase in the minimum wage. So we will talk about that a little bit. Thing about that is, when you change the hourly minimum wage, it also affects the minimum exempt salary for salaried employees as well. So we're talking about, your managers, anybody that's on salary that's not paid hourly, that is also affected. They have to be paid a minimum of $66,560 per year in order to continue to be exempt from overtime requirements, from meal and rest breaks, and that sort of thing. If you can't pay your exempt employees that much, or you don't want to, it's easy to transition them back to being hourly, because in the state of California, all employees basically default to hourly employees. So in other words, unless the company shows or proves that these employees are exempt, then they are technically hourly employees in the state. So with that, we do have some tips, a tip sheet on how to transition employees from exempt to non-exempt if you need to do that. So keep an eye out for that, or reach out to us. We could give you some help or some ideas with that thing. Question just popped up too about having a long-term care policy. Um, Not sure what that one is. We do have the workplace violence prevention policy that we're going to talk about. So, let's go through a presentation, see what topics we can cover here. We'll touch on that and see what information we can get you on that as well. Now, speaking of minimum wage, though, when we talk about it, we talk about the changes throughout the state of California, right? And we say, California has a minimum wage. Thing to keep in mind, though, is there's a lot of different local minimum wage laws that are actually higher than what the state requires. So the state of California gives us the floor. They say at a minimum, you have to pay people $16 an hour for non-exempt employees. But then different cities, counties, municipalities, whatever it is, they can choose to go beyond that. They could say, well, since the cost of living in this area is more expensive, you have to pay more than $16 an hour. And we do have that quite a bit, to the tune of over 40 local ordinances. So there's over 40 different minimum wages, or different laws, if you will, regarding minimum wage or other protections like paid sick leave, predictive scheduling, flex time, that sort of thing. So thing about that to keep in mind, the reason why this is important is, even if, say, the city of Glendale abides by the state minimum wage, if you have remote employees, or if your employees go to perform work in other areas where the minimum wage is higher, or where there's different protections for paid sick leave, then they are subject to those protections. So, for example, up here in Northern California, we're close to the Bay Area. So whenever employees if we have remote employees that work in the Bay Area, or that live in the Bay Area and perform their work there, they would be subject to those protections. Same thing in the city of Glendale. If you have employees that travel to other areas to perform work, and the first example that comes to mind is if you have landscapers that travel to other areas to perform work, and the minimum wage there is higher, or there's a different paid sick leave protection, since they're performing work in that area, they could be subject to those protections. So keep that in mind. That's why it's important to kind of know if there's any changes or any differences in your surrounding area, and of course to know where your employees are, right? We saw that during COVID, a lot of those remote employees moved around everywhere to different areas, didn't always communicate with us about where they were. Sometimes they moved out of state, creating, taxation issues and that sort of thing. So it's always important to know where your employees are working, especially those remote employees. So a little more information on that. I mean, some of these municipalities that saw increases that took place on July 1st of this year happened both Northern and Southern California. And these are just a few examples. In Northern California, we have the usual suspects: Emeryville, Alameda, San Francisco, of course. Southern California, LA County and the city of LA, they kind of had an increase that took place on July 1st. There was also Pasadena, Santa Monica, and the hotels in West Hollywood as well. Now, you'll see that bit.ly link there on the bottom of your screen. That will take you to a sheet that shows what the different minimum wages increase to in different areas of the state. So if you're curious about that, follow that link. Otherwise, you can go to our website, employers.org. Under the form section, we also have that information available. Now, speaking of minimum wage or wages as it is, I do have a question for you, or this thing came up, and this is related to a court case that took place this year. The question asks, before our employees start their day, we have a security screen process. Employees must scan their badges and go through a bag check and metal detector. The process is about 5 to 10 minutes each day as a line often forms. Employees then clock in to start. Is this okay? So what do you guys think? Is it okay to not start paying your employees until after they go through that security screening in this example? You can just throw an answer in the chat box if you like. If you think it's okay or not okay, you can just say okay or not or whatever you think. Let us know what you think. Got a couple no's popped up. Say nope, that's not okay. And there's a question that's kind of gone back and forth, right? And we've actually had that question asked by a few of our callers too. Hey, we have this process where we check people's bags before they leave or before they start their workday. Do we have to pay them for that? And again, that question's gone up and down. The law is, somewhat gives us some information on the subject. And as you know, in the state of California, when we're figuring out how to do things, we have the laws that are passed by the government, but then these laws are interpreted by different court cases, and that interpretation kind of gives us the understanding and the guidance on how to comply with that law. Well, that's what happened with this situation. And in this case, you said, no, that's not okay. And you're correct. That's probably not okay. So we had a case come through this year, was Huerta versus CSI Electrical Contractors. And basically, this just kind of reinforced the notion that, we should not have employees engaged in any kind of work before or after their shift that is off the clock. Again, that's, and most employers know that, right? You can't have employees work that are off when they're off the clock. You can't ask them to work off the clock. But this case kind of shed a little bit of new light on what constituted being on, performing that work on or off the clock. And keep in mind, of course, this case had very specific facts related to it, that sort of thing. But again, some of the things that came out of it are applicable to other situations. So let's look at some of the details in this case. And this one, basically, as I mentioned, on Huerta, the employer had a security checkpoint that the employers had to go through to enter or exit the work site. So we see that a lot. If you have like a warehouse location or something, maybe it's fenced in, and there's a checkpoint where you have to maybe scan a badge or where you have to be checked in by security, right? Very common. Thing about that is, the guards would have to scan each employee's badge and sometimes do an inspection in the vehicle, before the vehicle went through. So that kind of stopped the employee from their travel, stopped them from being able to get to the time clock, right? And this happened to the tune that sometimes it would delay employees anywhere from 10 to 30 minutes because of the backup that happened. If you have a guard going through somebody's car or looking through it, you got cars starting to stack up, especially because employees are just rushing to get to work. Sometimes they get there right in the nick of time. Well, that line's backing up. What happens? And the problem with that is that delayed people before they were able to clock in. So when the Supreme Court of California reviewed the facts of the case, they concluded that that time spent in that checkpoint, that security checkpoint, was compensable because this task, this inspection, was directed by the employer. So in other words, the employer still had some control over the employees at that point because they were being made to go through that checkpoint and had their belongings checked under the direction of the employer. So again, that control, that measure of control the employer had over the employees meant that this time was compensable. A little information about this case. I mean, this was basically the reason there was that much delay. This was a solar power facility that was up in the San Luis Obispo area, and basically, it was a checkpoint where they got delayed, and then they had to drive you a little further to get to the actual work site. Right, the guard shack was right at the entrance where the employees come off the road to go into the job site. So that delay between getting through the guard shack to being able to get to the work area and clock in, that was the time in question. So a few more things that, or some pro tips that came out of this. A lot of already, we don't want to have employees do that work before or after they clock in, right? We don't want employees working on or off the clock. And some things that could be considered work or under the employer's control are things like security screenings. So in other words, if you're checking your employees' bags or lunch boxes or whatever before they go into work or before they go home for the day, make sure that that's occurring on the clock, not off the clock, right? If they have to log in to the computer start working, or even log into the computer to clock in or out, that time could be compensable. Or if they have to start machines before they start work and they do that before they clock in, that is actually compensable time. Thing about those computers too, though, is if they have to fire up the computers to clock in, you may want to consider having one of those exempt employees, those employees that are not hourly and don't have to clock in, go through before everybody else and turn everything on to make sure that it's ready to be clocked in, right? Protective gear, they have to put on or take off any extensive protective gear. That should be done on the clock as well. And I'm talking about extensive stuff, right? I'm not talking about things like a hairnet or, maybe like a beard cover, anything like that. We're talking about, safety gear, safety suits, safety helmets, that sort of thing. Anything that takes a significant amount of time should be done on the clock. Easy one, of course, answering emails, phone calls, that sort of thing. If it's a non-exempt or hourly employee, that time is compensable. They should be paid for answering those emails, taking those phone calls, whatever it is. That is all compensable time. Same with at the end of the day, if you have to lock up and set the alarm on your way out the door, guess what? That is a task that's directed by the employer. That is compensable time as well. So if the time clock is all the way in the back of the building and they clock out and they have to walk all the way to the front, lock the doors and set the alarm, that time between clocking out and setting the alarm and walking out the door is compensable as well. So be careful with that. And of course, cleanup, right? Cleanup should be part of the work task for the day and is compensable as well. Some other issues or some other things that came out of this Huerta case, of course. There was a question about the drive time after the security check. And as I mentioned, this is like a solar farm. So once you get through a security check, they still have to drive quite a bit. And it was in protected land. It was like a park or something. So they had to go um, the speed limit, and there was a delay from the guard shack until they got to the parking area to clock in, right? It was like a 15-minute drive before they reached the employee parking lot. Well, what the court found was that that drive time after the inspection until they got to the official parking lot, that was not compensable time. So in other words, they took that as that's like a normal part of the commute, right? That's something the employee has to take into account when they're planning their day, when they're planning to get to work. They know that 15 minutes is there. Even if there's a speed limit, that speed limit is for safety. It's beyond the control possibly of the employer or the employee. So that has to be taken into account by the employee. That drive time is not compensable. They don't have to be paid for that. The other question that was asked and answered in this case was on-duty meal breaks. Now, there was a collective bargaining agreement between the union and the employer that the employees had to remain on the premises during their meal period. In other words, the union agreed that employees could not leave the work area. And as you know, if you've been on our labor law updates or any of our other presentations, you know that meals and breaks are the employee's time. They are, we have to completely relinquish our control over them, which means they are free to come and go as they please during that break time. So the court found that that right to be able to leave the premises or do whatever they want with their meal or rest break is not a right that could be waived even under the collective bargaining agreement. So they found that employees had to be paid for those on-duty meal periods. So some other pro tips that arise this this second part: beware of those on-duty meal periods, right? if you're having on-duty meal periods for your employees, keep in mind they're rarely permitted. It's only when, the nature of the work really doesn't allow the employer from taking their meal break. So if you do have those on-duty meal breaks, make sure that you have an agreement in writing, the employee is voluntarily doing it, right? Otherwise, if you do have meal and break periods, make sure your employees are allowed to leave the premises. Remember, we are fully relinquishing control of our employees during their meal to break time. That is their time to do as they wish. So if that means they want to drive, if they have a 15-minute break and they want to drive 7 minutes one way, spend 1 minute at the store and drive 7 minutes on the way back, that is on them. They are free to do whatever they want as long as they leave on time and come back on time, right? Of course, if there's a violation, if they don't take a sufficient meal break or, you don't allow it or whatever, make sure premium pay is paid to them at the regular rate of pay, right? And make sure that anytime you have to pay a meal premium or a break premium, that shows up on their pay stub or on their wage statement. And finally, that premium pays in addition to any hours worked. So if somebody works, cuts their lunch short by 10 minutes or whatever, you have to pay them for those 10 minutes that they worked on top of paying that meal premium as well. So it's not just either or, I'm paying the meal premium, so I'm not going to pay them for the time worked. No, you still have to pay them for the time worked, and the meal premium or that meal penalty, if you will, has to be paid on top of that as well. All right, let's move on to some health and safety updates. This was actually a pretty big year for health and safety too. We saw some changes come through, mainly in the workplace violence and protection and heat illness protection as well. So I'm gonna get a drink and we'll talk about these for a bit. In just a moment. All right, so let's start with the Workplace Violence Prevention Plan and the requirements. Now, this requirement came through mid-year, and basically it said that by July 1st of 2024, employers had to establish, implement, and maintain a written workplace violence prevention plan. Now, thing about that was that there was different requirements to this. A lot of us are familiar with injury and illness prevention plans or IPPs. Well, the WVPP had a requirement that there had to be employee engagement and there was some annual training requirements attached to it as well. So, employee engagement means that your employees have to be involved in the creation and basically the maintenance of the plan. We'll talk about how that works here in a bit. And of course, annual training is every year, at least once a year, you have to retrain your employees on those requirements and the Workplace Violence Prevention Plan requirement. And of course, I mean, this basically this requirement applies to almost every employer across the state of California. There are very few exceptions and they are very, very limited as well. So some of the exceptions include any employer that's already covered by a workplace violence prevention plan. In other words, healthcare has had this requirement for a long time. So healthcare facilities would not be subject to this because they were already subject to a workplace violence prevention plan requirement. Um, any employee that's teleworking from a location of their choice. In other words, if you have a remote employee that's working from their home or they get to select the place where they work, and that's how your employees work, they're not subject to this requirement because they're the ones choosing where they work. You're not directing them to work in your office or in a specific location. Any places of employment that are not accessible to the public and have less than 10 employees working at any given time and have an IPP in place. Now, be aware of that one. The term not accessible to the public is not really defined in the statute. So if you think that you qualify or you fall under that exception, we recommend that you consult legal counsel on that one. And finally, any facility operated by the California Department of Corrections and Rehabilitation or law enforcement agencies are also not subject to this requirement because they already have workplace violence measures in place. So, and of course, there's always the stick that comes along with it, right? Penalties for not having a WVPP in place can go up to $25,000 for violations that are classified as serious, or up to $153,000 for what are considered willful violations. So is Cal OSHA going to go knocking door to door asking people specifically for workplace violence prevention plans? I don't know if they're going to send people out looking specifically for this, but if you do get a visit from Cal OSHA, you can be pretty sure that they're going to ask to see that workplace violence prevention plan and make sure that you have the documentation for that. So again, very important to make sure you have that in place. We do have a lot of resources for this on our website, employers.org, free to the public, so make sure you take a look at that as well. Now, when we're talking about workplace violence, what kind of things qualify, or what examples can we give for that? Well, first one is any kind of physical attack with or without a weapon. So if somebody punches somebody else at your place of work, that would count. If somebody hits somebody else with, you know, a stick, a shoe, a 2x4, a stapler, whatever it is, that also counts as an example of workplace violence. Any threat of physical force or use of a weapon. So if there is a threat between employees, hey, I'm going to punch you, I'm going to hit you, I'm going to beat you up, I'm going to hit you over the head with my desk, that threat counts as an example of workplace violence. Sexual assault or unwanted verbal or physical sexual conduct. So if you have a sexual harassment complaint, guess what? You also have to look at the facts of the case, because that sexual harassment can also be a form of workplace violence. And this is an interesting one. Animal attacks are included as a form of workplace violence. So we have a lot of our members that are, veterinarians, pet groomers, that sort of thing. Any animal attack is also considered workplace violence and must be, one, prevented to the extent possible, and two, recorded, right? So if you have delivery drivers, think about them. A lot of times they're delivering something. Homeowner has dogs, so that could be an issue as well. Now, saw a question pop up here. Does a workplace violence plan apply to remote workers? Again, if your workers are 100% remote and they work in the place of their own choosing, more than likely it doesn't. However, if you have like hybrid workers, or you have them come into the office from time to time, or into your place of business, then yes, you have to have a workplace violence prevention plan for your place of business. And any of those employees that are asked to come into work there, whether it's one day a week, once every couple of weeks, once a month, whatever it is, they have to be trained on the specific one. Now, as far as having a workplace violence prevention plan for their home because they work out of their home, you're not going to do that. It's just for the place of work, for your place of business. Okay. So some key requirements for the WVPP. Of course, create the written plan, right? Cal OSHA gave us a nice template that we can use. Basically, it's got, the parts that you fill out highlighted in red, so you can go through, familiarize yourself with that plan, and, take their suggestions and complete it. As I mentioned too, employee feedback is a part of the requirement for that. So before you finalize your plan, you have to solicit employee feedback in the form of a surveys or a town hall meeting, or, suggestion box, whatever it is, 800 employee line, whatever it is. You have to get their employee feedback and suggestions on any workplace hazards or workplace issues, and if applicable, incorporate those into your plan. Employee training has to take place at least once a year going forward on that workplace violence prevention plan. And you also have to have periodic inspections and hazard corrections and safety meetings. What's periodic mean? It's up to you, right? I mean, at the very least, I would say once a year. I mean, as far as those hazard inspections go, you can have them as often as you want, depending on what your business looks like. So you could have them once a week, once a month. You could have your managers do them, whatever it is, and those have to be documented as well, all right? If you have any incidents of workplace violence, those must be investigated. Okay. And of course, if you have any findings where it could be prevented, or any changes that could be due to do this, then make sure that you're documenting how you address that. There's record keeping requirements that come along with the workplace violence prevention plan too. So these include things like a violent incident log, or those hazard correction and hazard inspection forms. Make sure that you are keeping track of those, filling out those logs. And if you need any additional help or don't know where to start, we do sell a DIY package for creating your workplace violence prevention plan. So keep an eye on that, or give us a call to get some more information on that. Now, question came up, very specific one about having clients who are the only employees. Do they need a plan? Give us a call on the hotline so we could talk about the specifics about that. and talk through it to see if this is something that applies to you as well. Okay. Next safety topic, or next change we saw to safety this year, is the indoor heat illness standard. Now, in the state of California, we're pretty familiar with having that outdoor heat illness protection, right? It's been on the news, it seems every year, construction workers, agricultural workers, landscapers, anybody that works outside. It seems that every year at least, we have some kind of fatality out there due to the heat. And as heat waves keep increasing, we kept seeing it more and more. Well, Cal OSHA's been kicking around having an indoor heat illness standard, and this is for places that are subject to high heat and they work indoors. Think commercial kitchens, perhaps, or manufacturing facilities where there's furnaces or ovens or welding or that sort of thing where there is a lot of high heat. Well, that is what this standard was aimed at. Now, this came into effect July 23rd of this year, 2024. And basically, it puts in different measures that you have to take whenever the work area reaches predetermined temperatures, in this case, 82 degrees when employees are present. So again, this is mainly aimed at manufacturing, warehouses, restaurant kitchens, any place without full AC. So a question you often get is, well, if it's an office environment and our air conditioning goes off, does this apply to us? Not necessarily, but at that point, we're using common sense, right? If it's 110 degrees outside and your office's AC goes out and the temperature starts to climb, you probably want to make some changes, whether it means send everybody home or whatever it is. Keep that in mind. But this, again, is aimed at, manufacturing facilities, warehouses, restaurants, places that constantly have that high heat, either throughout the whole work area or in different areas as well. So some of the requirements in this heat illness prevention plan is water, of course, right? Having potable drinking water for your employees, having designated cool down areas. Now, this could be something like a break room. If you have a break room or a break area that's air conditioned, perfect. That's it. That usually qualifies, right? Having written emergency response procedures. So what do you do if someone becomes affected by heat illness? If someone feels faint-headed, if someone, is showing symptoms, what do you do? And also acclimatization procedures. Now, what this means is giving your employees a chance to become used to or become accustomed to that high heat. So in other words, if you're in a manufacturing facility that makes, say, glass, for example, and you have like a furnace area or a, you know, area that's very high heat and you hire a new employee, you kind of ease them into it, right? Give them additional breaks, maybe check on them on a regular basis. Maybe, you vary their shifts a little bit so until they get used to that high heat. That's what acclimatization means, just giving them the employees' bodies a chance to um, get used to that environment. Okay. Other requirements include having a written heat illness protection plan. So that's another thing to add to your bookshelf, right? Having training for employees and supervisors. There are training requirements for this, and I mean, at least with the outdoor heat illness, we know that that training happened at the beginning of summer every year. Well, this one, if it's a constant throughout the year, make sure you plan that out. Make sure you schedule that. When are we going to do our indoor heat illness prevention training? Make sure you have that on your calendar at all times. And of course, the high heat requirements, right? So, there's things that are triggered when the temperature reaches 87 degrees or 82 degrees, but the employee's wearing restrictive safety clothing. So if the employee's like in the full-on, suit to protect them from a furnace or whatever, and the temperature around them reaches 82 degrees, guess what? It's probably hotter in that suit. So different protections are going to be triggered. And those include things like additional breaks, maybe additional monitoring, that sort of thing. So keep that in mind now. If you're already familiar with the outdoor heat illness standard and the outdoor heat illness protection plan, the indoor is very similar to it, to the tune that Cal OSHA on their website has basically put the two templates side by side or together. So again, something that you can access through our website. We do have the links to those templates and to that information. All right, let's move on from safety to some new rights and protections for employees. And this includes things like for pregnant workers, changes to harassment standards, and also artificial intelligence, something that's become kind of a buzzword, or a couple of buzzwords, if you will, for the last year or so. But let's start with the pregnant workers. And this actually came from the federal government. This was the Pregnant Workers Fairness Act, or the PWFA, and that was passed in June of 2023. but regulations became effective in June 18th of 2024. Now, this is very similar to the Americans with Disabilities Act. If you're familiar with that, if you've engaged in the interactive process or had employees that were disabled, kind of modeled after that a little bit. Now, this applies to employers with 15 or more employees. So if you're a very small employer, you know, this you kind of missed the cut on this one, if you will. Um, but basically, you know, this expands on those Americans with Disabilities Act protections because it basically, you know, requires any employers to accommodate any limitations that are related to pregnancy, childbirth, or any of the medical conditions related to it. So, in other words, morning sickness, we know that that's usually related to pregnancy. Migraines, the need to have additional restroom breaks, the need to carry water, that sort of thing. Those are all predictable accommodations or predictable limitations that qualifying employers need to address, even without a doctor's note or anything like that. You know, if an employee lets you know, hey, you know, I'm pregnant, I may need to take additional bathroom breaks, you have to accommodate that. Or, hey, you know, I'm calling in this morning, I'm gonna be a little late. I've got morning sickness, gotta accommodate that now. And again, this came from the federal government. So as you know, California has some pregnancy protections as well. Let's review those really quick. So under California protections, now the California's protections apply to smaller employers. So they apply to employers with 5 or more employees. And what California states is that employers have to reasonably accommodate employees disabled or affected by pregnancy as certified by their healthcare provider. In other words, if the doctor provides a note, certification, whatever it is, saying, hey, this employee is temporarily disabled due to their pregnancy, they need to be on bed rest, they need to miss work, they need to work reduced hours, whatever it is, then if you have 5 or more employees in California, you have to accommodate that. And that's to the tune of 17 in the third week, so roughly 4 months. That can be up to 4 months of pregnancy disability leave as long as it's certified by the healthcare provider. So in other words, if your employee comes to you and says, hey, you know, I'm pregnant, I want to take a month off before my birth, that's great. Do you need it medically? Well, yes. It's like, okay, well, bring me a doctor's note that states that. Please document that. Please give the certification for that. Or you go to the Civil Rights Department website and download the template of, you know, the form that their doctor fills out. Now, there's also protections against discrimination, retaliation, or harassment against pregnant employees. So, if an employee comes and lets you know that they need, you know, time away or they need some time for their doctor's appointments for pregnancy, and you give them a hard time about it, you make fun of them, maybe you cut their hours without asking them or something, that could be seen as a form of discrimination or retaliation, which is against the law. So again, be very careful with that. Even if your heart's in the right place, even if you decide, hey, you know, so and so told me they're pregnant, and you know, I'm going to cut their hours so they're not working that hard. Your heart may be in the right place, but that could be seen as a form of discrimination or retaliation. So again, stick to what the doctor asks you to do in these cases. So we talked about the new federal protections, now the California protections. The question is, do the new federal protections impact California employers? We know usually California provides more protections for employees than the federal government does. Well, actually in this case, they kind of flipped the script on us. In this case, the EEOC's regulation is actually more protective than what California offers for those with 15 or more employees, that is. And the reason why is that the new federal guidelines state that employers must temporarily suspend essential job functions if the employee cannot perform them. So under California's law, it used to be that if a pregnant employer comes to you and they can't perform the essential functions of their job, they'd go on a leave of absence, right? Say you have somebody that's a material handler and they say they can't lift more than 5 pounds and their whole job, you know, involves them moving 10 or 15 pound boxes. You say, well, you can't perform your job, go on the leave of absence. Well, under the federal regulations, it says that you must temporarily suspend those essential job functions. So you say you don't have to do that. You could do something else instead for the time being. So very interesting one there, right? The other one is providing certain predictable assessments. And that's what I was mentioning earlier, you know, letting in carry water, maybe taking longer breaks or taking additional breaks to use the restroom, sitting when standing is required, or vice versa, that sort of thing. Anything that's predictable, employers should be providing that without the need for medical certification. And that's the tricky part, right? With California, we could say, hey, you know, if you need accommodations, that's great. You know, let's get your doctor's note and see what the doctor says. Well, federal government says not so fast. If it's for pregnancy, there are certain predictable assessments that employers should be doing once they're notified without the need for medical certification. So communication is going to be key on that one, right? So let's look at an example of this one. In this case, we have an employee that's Erica, who's pregnant, and she presented a doctor's note certifying she can no longer lift for the remainder of her pregnancy. Lifting is an essential function of her job, so how do we respond? Well, and this I alluded to this earlier. In this case, according to the federal government, the EEOC, if a pregnant employee is temporarily unable to perform one or more essential job functions, then you may need to offer things like light duty, change their work assignment, or any other change unless you can demonstrate an undue hardship. So you're going to keep them at work, modify their job, maybe offer them a different job that's available as long as you can show, or unless you can show that there's an undue hardship, right? Or that it's not a reasonable accommodation. And the thing about that is, if you believe it's an undue hardship to accommodate that thing that's being asked or thing needs to be done, we always recommend consult legal counsel for that. You know, whether it's for pregnancy or whether it's for a another disability, if you are saying that you cannot accommodate because it would create an undue hardship for your business, always consult legal counsel on that, because those exceptions are pretty narrow, and the whole burden of proof on that is on the employer. So you want to make sure that you're staying within legal bounds to claim that, right? And that's where legal counsel can direct you and make sure that you do not get in trouble for that. All right. So again, in this case, if this employee can't lift and lifting is an essential part of their job, I mean, you at this point now you're looking for other accommodations at work, maybe a job transfer, different job, whatever it is, instead of just automatically going to the leave of absence, right? Which is required under California law. So again, kind of makes us do a little more legwork in this case. And it looks like the federal government really is looking for us to find a way to possibly keep that employee working safely during the time possible for their pregnancy. Some additional information related to this too, on lactation. California has a lot of protections on lactation in the workplace, right? And we do have some information for CA members, whether it's things like a lactation accommodation notice and request forms, that sort of thing. There's also some additional protections under the federal government on what they call the Pump Act back in 2022. Now, the thing about this new EEOC regulation also changed the topic of lactation a little bit. And they stated that a lactation accommodation can include things like permitting an employee to nurse during work hours if the child is in what is considered quote unquote close proximity. So if you have a daycare center on site, then allowing your employee to go nurse their child is considered a reasonable lactation accommodation. If the daycare where their child is, 2 buildings down from where you are, allowing them to go and nurse their child is considered a reasonable accommodation. Now, if the daycare is across town, that's a different story. So again, you got to look at these things on a case-by-case basis. But again, it's not just about providing lactating parents a place to express milk anymore. A reasonable accommodation can also be permitting them to nurse the child during work hours. So again, engage in that conversation, engage in that interactive conversation with the employee to see what is necessary and what you can do to accommodate that request. Yeah. All right, I mentioned changes to harassment guidance, and this also came from the federal government. So the federal government really put it in gear in 2024, it looks like. And this change comes after almost 25 years of not touching the harassment or discrimination guidance. This came from the EEOC, and basically they updated their guidance with 77 new examples and clarifications of what constitutes harassment in the workplace. So some of these examples include asking intrusive questions about sexual orientation, gender identity, gender transition, or intimate body parts. So hopefully your employees through your harassment prevention training already know not to ask inappropriate questions or uncomfortable questions of their coworkers, whether it's related to their gender, gender identity, religion, race, anything like that. But, you know, in this case, the federal government clarified that said, hey, if someone's making intrusive questions about somebody's sexual orientation or intimate body parts or what have you, that can constitute harassment. Okay. The other one, harassment of LGBTQ plus workers can include denial of access to bathrooms consistent with their gender identity, right? Or repeatedly and intentionally misgendering somebody. That is also now considered an example of a form of harassment by the federal government. So very aware of that. If you have, if you don't have um, single use bathrooms or that sort of thing, then denying people access to the bathroom that's consistent with their gender identity can be a form of harassment as well. Of course, harassment based on pregnancy, childbirth, or related medical conditions, of course, also has been clarified as a form of harassment. And just as important too, harassment can occur in remote work environments. So, as we know, since the Great Plague of 2020, a lot of remote work has really become something that more employers are doing. So, in this case, be aware that harassment can also occur in those remote work environments. We have different ways of communicating, whether it's text, email, instant messaging, or whatever. So, be aware that we can also someone can also be subject to harassment even if they work remotely, even if it's not in person, it can also be a form of harassment at that point. All right, let's talk about artificial intelligence now, and another recent court case involving artificial intelligence. We've all heard of things like, the different. Basically, it seems like every software company is coming up with their own form of artificial intelligence, whether it's ChatGPT or, Google or whoever it is. They all have a different one. Well, we have a court case associated with this. This one is Mobley versus Workday, and in this one, a, an AI company was providing resume screening services to another organization. As we know, we've talked about this in the past. There's programs to basically sift through or sort out resumes, look for candidates, that sort of thing. Well, that's what was going on in this case, right? But the EEOC found that that resume screening service could be directly liable for discrimination. So what happened here was the plaintiff alleged that Workday was basically through their algorithm or their AI system, whatever it was engaging in the pattern of or practice of discriminatory job screening. And what this was doing, it was disproportionately disqualifying African Americans, individuals over 40, and individuals with disabilities from the workplace, right? Was it on purpose? Was it not? Who knows? But that was the impact that it was having, right? So it might have just been the way it was written or the information that was entered, whatever it was basically adversely affecting those specific protected groups. So again, be very careful if you're using AI or if you're contracting with a company that uses AI, whether it's for employee management, for resume screening, whatever it is. It's always a good idea to maybe audit the information that you're getting just to make sure that you're getting the results that you expect or that it's not disproportionately or adversely affecting specific protected groups, right? Um, Stay up to date on those AI developments. Those things are changing every day. The information on there is evolving. Maybe have a committee or whatever it is. But if you're a company that, uses it, make sure you stay up to date on it. Make sure you know, you know what the changes are and how it's affecting you. And of course, we always recommend if your employees are in a position where they can use AI to perform part of their job, or if they're writers or they're writing policies, if whatever it is, put a policy together as to when the usage of AI is appropriate and permitted and when it is not. Now, we do have a sample policy available for CA members too. So, but if you have any questions about, putting a policy together or what you can do, that sort of thing, give us a call on that hotline, especially again, if your employees are in a position where they can use it to do their day-to-day jobs or perform any tasks related to your organization. All right. Now, the healthcare minimum wage, this is something that, has been on and off of the news a lot this year. It was supposed to take place or come into place earlier this year, and the governor suspended it basically due to the finance of the state of California. I'm not saying the state's broke, it's just not doing as well as it could be. So the governor decided to postpone this for the time being. Now, the goal was for healthcare workers to earn up to 20 or to have a minimum wage of $25 an hour, and it was going to be a gradual increase until it got to that point. So basically, initially, the wages were going to range from $18 to $23 an hour. And again, this was supposed to come into place, I believe, earlier in the spring. Well, finances weren't what they should have been, so the governor pushed it down the road. Now it's going to come into place either in October 15th of this year or January 1st on next year. And that's dependent on California's revenues through the month of September. So again, September's not over, the books aren't closed, but depending on how the state's finances have performed through September, that's going to determine if this increase starts to take place on October 15th or if we're going to wait until January 1st. Chances are it's going to be pushed until January 1st, but keep an eye on it just to make sure to see if it's going to have to come into play this year. Now, this also modifies, exempt or affects exempt employees in those healthcare industries too. Exempt employees, as I mentioned earlier, you have to be paid either 2 times California's minimum wage or 1.5 times the healthcare minimum wage, whichever of the two is greater. So it's, gonna have to bust out our slide rules and see what that calculation is, what we should pay our exempt employees in the healthcare field. So let's look forward here. What's next for California employers? What should we be doing? Well, first one is, of course, we talk about minimum wage and we talk about how it changes every year. So make sure you're paying your employees correctly, whether it's your hourly employees or your exempt employees. Keep an eye out. We're going to see if there's an increase for 2025 as well, and make sure we're capturing all hours worked. So how are we tracking our hours? Is it paper time cards? Is it a digital clock system, whatever it is? Make sure you're capturing all those hours worked. There's no work being done off the clock. Make sure you have a workplace violence prevention plan. Make sure you're up to date with those requirements if it applies to you. And, you know, take a look at it. Like I said, this was mandatory as of July 1st. If you haven't done it and it applies to you, I guarantee you're not the only organization that doesn't have one in place yet. Just, take a look at it, start working towards it, get that employee engagement, and start working on it if it applies to you. Get that in place. Um, if you have if you have a pregnant worker policy, or even if you don't, if like, these changes apply to you or affect you, make sure you update your policies and your trainings regarding those pregnant worker accommodations and harassment. And I'm talking about your managers, middle managers, supervisors. Make sure they are aware of these protections for employees, because a lot of times, when organizations get in trouble, it's because those supervisors, those middle managers did not have the training or were not aware of those requirements. So make sure you're training, anybody that interacts with employees, that supervise employees on those protections, give them the information necessary, or let them know who to go to if they find themselves, faced with that situation. And of course, for any changes, you can subscribe to our blog, whether you're a member or not. Always putting out information about upcoming changes or recent changes or things to look out for. So it's always a great place to get information. So with that, I'd like to thank the city of Glendale for allowing us to be a part of to take up your lunch hour, if you will, with this webinar. Again, I'd like to remind you, if you have any questions, you can call the hotline 866-248-3074. If you have any questions about the topics we talked about today or any other HR topic, give us a call. And with that, I think I'm gonna turn it, or hang on, a couple more things actually, sorry. If you need any help, you think beyond the hotline or anything else, we do offer memberships for CEA. So these start anywhere from a monthly membership all the way up to our ultimate membership. Each, as you go up the ladder, if you will, there is more benefits available to you. So take a look at that slide. If you have any questions, give us a call. We'd love to talk about that with you and some of the benefits of membership, some of the benefits membership can provide, if any of you remember that old Amex commercial. If you need help on site, if you maybe need someone to go perform some of the HR tasks at your location, maybe, you have your HR director is on leave of absence or something, you need somebody to take that seat for a while, we do offer HR assist. In other words, we can place somebody in your location to oversee that HR task, or we can do it virtually as well. Either one works. So again, if you have any need for additional HR help, whether it's somebody on site or somebody to help with those employees issues or employee, tasks or policies going on day to day, give us a call. We can offer that for you. And if you're here for continuing education, I do have those codes for you. Thanks for sitting through this with us. If you need HRCI codes, they're 679709. Or for SHRM, it is 24-K23CQ. Do not forget that dash. SHRM really loves that dash, so if you leave it out, you won't get full credit. Now, Stephanie did mention we do have that survey for you, so we would love to hear from you, what you liked about this presentation, what you'd like to hear about, anything that's on your mind. It's a brief one. It's very quick, but we do appreciate that feedback. So please, scan that QR code and let us know. Let us know what's going on in your world. Let us know what you're thinking. Let us know how we can better serve you and help bring you peace of mind. With that, Stephanie, I'll turn it over to you. If you have any final words for our listeners.
I do. We actually got a question in the chat box that I'm not sure if it got addressed, so I just wanted to bring it up just in case. During the workplace violence prevention slides, somebody mentioned that they have clients who are the only employee, and they were wondering if they still needed a plan.
For clients, I'm wondering if that's like a temp agency sort of situation or something. Um, I mean, if you have a location, a business location, like an office or something, you're going to need a workplace violence prevention plan, right? Especially if you're public facing, if they come into your office, if you do anything there, you're going to need to have one. But for that one, give us a call on the hotline. Let's talk about the specific details there, and we'll see if that is something that you would need to have or not.
Yeah, awesome. Thank you very much.
All right.
All right, so please give us a call on the hotline Monday through Friday, 8 to 5. We are here to answer all your questions, submit the survey, and we will see you next time, Glendale. Thank you.